Save login, register or subscribe to save articles for later. Normal text size, larger text size, very large text size. Religious schools and LGBTQI students are once again at the center of the federal political debate. Fair enough if it seems like Groundhog Day. There has been talk about law reform in this area since the legalization of same-sex marriage in 2017. Now there is a federal government proposal to prevent religious schools expelling students for being gay. It sounds simple, but it turns out to be anything but. What is the proposed change, and why is there so much debate about it? Credit. What does the law currently say? Religious schools enjoy wide-ranging exemptions to anti-discrimination laws. Specifically, the Sex Discrimination Act stipulates that it is not unlawful for a religious educational institution to discriminate against a person on the ground of their sexual orientation, gender identity, marital or relationship status, or pregnancy, as long as the discrimination is in good faith in order to avoid injury to the religious susceptibilities of adherents of that religion or creed. This provision is contained in Section 38 of the Act. It was last changed in 2013, when the then Labour government overhauled anti-discrimination laws to protect people from discrimination over not only marital status and pregnancy, but sexual orientation and gender identity. Exemptions for religious educational institutions were changed to include those attributes. Advertisement. What is the government now proposing? The proposed amendment would not delete the aforementioned exemptions. Instead, it would add a caveat: notwithstanding everything else in the section, it is unlawful for a person to discriminate against a student on the ground of the student's sexual orientation by expelling the student on that ground. Loading. So, put simply, a religious school could no longer expel a student for being gay or bisexual. They could still expel a student for being transgender, and all LGBTQI students could still face discrimination other than expulsion. Why is it controversial? The change in itself isn't controversial at all. Pretty much everyone, including the Australian Christian lobby, agrees schools shouldn't be able to expel students for being gay. The debate is about all the stuff that won't change, and the fact it creates an explicit difference in the way discrimination law applies to gay students compared to trans students. Advertisement. Liberal MP Dave Sharma drew attention to the concerns on Wednesday morning, saying, "We need to bear in mind here that a student can quite easily be forced out of a school without being expelled. If they are harassed or intimidated or bullied or made to feel unwelcome or unsafe, of course they are going to leave." Why is the government doing this? The coalition government has a long and complicated history with this area of law. It was Philip Ruddock's Review of Religious Freedom, commissioned by Malcolm Turnbull upon the legalization of same-sex marriage, that drew attention to the exemptions enjoyed by religious schools. Finalized in 2018, the review recommended keeping, but tweaking those exemptions. In the ensuing debate, Scott Morrison, by then Prime Minister, said he did not support students being expelled because of their sexuality, and vowed to change the law. But disagreements about how far those changes should go, similar to the arguments of this week, led to those plans being dumped at the end of 2018. The government asked the Australian Law Reform Commission, ALRC, to examine the broader issue of discrimination against LGBTQI students and teachers, with a brief to report by the end of 2019. At the same time, it pressed ahead with a religious discrimination bill to better protect people of faith from discrimination. Then what happened? In short, the ALRC and the government agreed it was futile to review anti-discrimination laws while the religious discrimination bill was in the works, and paused the inquiry before it had started. But by the start of 2020, the religious discrimination bill was on the back burner due to bushfires and the pandemic. Advertisement. Its return at the end of 2021 led several Liberal MPs to pressure the government to revisit the issue of discrimination against LGBTQI students, the unfulfilled vow of 2018. Shortly before Parliament resumed this year, Morrison confirmed he would move to change the law in some way to ensure that kids cannot be discriminated against on that basis. What are the issues at play? Loading expulsion for being gay is the thin end of the wedge. Religious groups have always maintained this doesn't happen, and there seem to be few examples. That is why groups such as Equality Australia, which advocates for LGBTQI causes, argue the proposed change is woefully inadequate. Schools and teachers could keep discriminating in many other ways, including questioning or refusing to recognize a student's sexuality or gender identity, punishing them, withholding or denying leadership opportunities, or refusing to let a student take their same-sex partner to the school formal or express their gender identity at such an event. For example, the controversy that prompted Morrison to commit to some form of legal change involved a Brisbane school, Cedar Point Christian College, issuing families with a contract that denounced homosexuality as sinful and warned the school would only enroll students whose gender corresponds to their biological sex. The proposed change to Section 38 does not make that situation unlawful. Following media attention, the school withdrew the contract and its principal stood aside. The school is also under investigation by Queensland's Non-State Schools Accreditation Board. Advertisement. The government argues it is not creating any fresh discrimination, and it does not necessarily endorse the existing laws. But it says a wholesale abolition of Section 38(3) would imperil single-sex schools because it would make it unlawful to discriminate on the basis of gender identity. For example, a girls' high school could be compelled to provide for a student or students who transition to boys. Attorney General Michaela Cash says it is crucial any changes to that part of the law are worked through in detail by the ALRC. Striking the balance between any individual's right to want to change their sexual identity and other parents' and children's wishes to go to a single-sex school must be sensitively managed, she says. Equality Australia argues this is a poor reason to delay reform as trans students generally prefer to be at a school that affirms their gender. And in any case, Section 21 of the Act allows all single-sex schools to exclude a child not of that sex, whether or not that child is trans. There are no proposals to change that section, and single-sex public schools manage this situation without the additional exemptions afforded to religious schools. What happens next? The government is offering this amendment on gay students as a package deal with the Religious Discrimination Bill. On Tuesday, the bills were ticked off by the coalition party room, although several MPs on that side of the chamber still have reservations, and it is not clear the government has the numbers. Angie Bell, a gay Liberal MP from Queensland, said she will vote for the package because it was a net gain for gay rights. Tasmanian Liberal MP Bridget Archer has indicated she will not support it. Labor was meeting on Wednesday morning to discuss its position. It will propose a series of amendments that extend protection from discrimination to transgender students and LGBTQI teachers, as well as other amendments to the RDB. It was not immediately clear how Labor would ultimately vote on the bills if those amendments are not successful. Advertisement.